Orders on an ex parte motion. This chapter also includes a skeletal form of order to show cause, and forms of written motion, and a notice of hearing on written motion. Okay, order to show cause. All an order to show cause is this. If you go into a hearing without the other party, okay? Now everybody should have their day in court. I mean, that's just fair play. No matter how right or wrong, you get your time in court where you say what you're going to say to justify whatever you did or want to do or so forth. Okay? So, but sometimes that isn't always possible. Maybe you have an emergency situation or something. So what you do, you might end up in court ex parte, meaning without the other party. Now, sometimes a situation comes up where it's so important, so timely, that we don't have time to go through the normal channels of putting together a motion and then having the other person respond months later, you know, that kind of thing. So, for example, the court itself might make a motion. You say in your paperwork, the court on its own motion does such and such and issues this order. And so you say that right in the paperwork that it is originating with the court, not with the parties. So you issue this order. Well, is that fair to subject anybody to an order without ever hearing from them? You know, you heard some situation, whatever it is, and the court decides to move on its own. Well, of course, it's not fair. So what you do is you issue the order, you put all your reasoning process in, the whole shot. It's just you haven't heard from the other side or from whoever's affected by it. So, in addition to your order, you have a second order. And this order is called an order to show cause. And what you're saying is, all you folks out there that are subject to the first order, if you do not obey this second order, then you must come back and show cause, or in other words, show a reason why you disobeyed the order. Because maybe the court issued an unrealistic order. The court could have said that we declare an emergency and everybody must walk around at least 1 inch above the floor. Okay? Well, obviously that's not realistic. You get an opportunity with a show cause order to come back and say, well, I can't walk 1 inch above the floor because I don't have my flying shoes and they haven't been invented yet, or whatever the excuse is, you see? But you always issue an order to show cause whenever you do something without the other party. When we issue our orders before a hearing, yeah, that's what we did, order to show cause. That's very, very important. It keeps you out of trouble too, because you know nobody can argue. And you know what the beautiful thing is? They never show cause. I've never had them come back and show cause. Okay? Yes.
So does that mean if you don't show up in court, I thought you usually just lost by default?
Well, normally you do, sure. I mean, that's typical.
Saying that when you lose by default, then there's an order in there that orders you to do something, and then...
Well, it's not magic. I mean, when you're served with the order, you also are served with the order to show cause. Okay, that goes with the package.
Can't you do that rather than a notice of demand?
All right, you're missing the point here.
So what I'm saying is, so you don't, even if you've lost by default, you still have a recourse because then you're challenging this order to show cause?
No, you didn't lose by default. What you got is an order.
So
losing by default means that you didn't pay attention to the arguments, and after you did not show up, an order came out affecting you. This is the order already came out and it affects you. Okay, so there's no losing by default. You've already lost if the order adversely affects you. But now you're in a position of not obeying the order.
Oh, I see.
Okay?
Yeah.
So, well, maybe the reason you're not obeying the order is that there's no such thing as flying shoes. Okay? Or whatever. So you've got to come back and say, I did not obey the order because. But see, that keeps you from being in contempt of court. But it's the other way around too. When you issue an order out of your court, you also, and if the parties have not had a chance to present their arguments, you must put an order to show cause with it so that they have an opportunity to speak if they're not going to obey the order. Mm-hmm. Because you can, it's possible you're in what do they call it, an ivory tower, and you just don't, you don't know reality out there. Mm-hmm. So you always give the other side an opportunity to express it. But like I said, I've never had anybody come back and show cause on any of my orders. Mm-hmm. Okay. They just automatically stick. Mm-hmm. What's next, sir?
Okay. I don't think I understand challenge jurisdiction as well as I thought I did. Is that pure and simple, provide a person that swears they were harmed, or is there more to it than that?
No. All we're saying by challenge jurisdiction is that they did something, whatever it is. They took jurisdiction. How do I know they took jurisdiction? Because they're ordering around. They're suing you. They're taking jurisdiction. They're saying you're a bad guy, and because you're a bad guy, we want damages, or we want to put you in jail, whatever the reason is, okay? You're saying, so that's the jurisdiction, because you can't go to the beach anymore, you got to be at the court hearing, whatever it is. All right, so now what you do in your counterclaim, you say, hey, what are you guys doing? You use better language than I'm using, but you're saying, what are you guys doing? You don't have the authority to do this, Before you proceed any further, either show your jurisdiction or pay for my injuries. Because my injury is that I lost my right to freedom. I now have to work at your direction. You're telling me to file answers when you don't even have the jurisdiction to sue? Or you don't have the jurisdiction to arrest me, or whatever it is? Okay?
But they will say, we've already shown you jurisdiction. That's why we sued you in the first place.
No. They haven't. They got to prove the jurisdiction. It isn't enough to just say, oh, we got jurisdiction, and arrest you. It's not enough to say that, well, the penal code such and such says it, so and so and so and so. Because your issue is you're sovereign. You're not subject to the penal code. Okay? Is it an act of treason to go against the sovereignty of the state? It's a good question to ask, All right? Because government code, which they are subject to, you're not, but they are, specifically says the sovereignty lies in the people, and it also specifically says that the people do not yield their sovereignty to the agencies which serve them. If you're an agency that serves the people, what are you doing going against the sovereignty? Okay, I'll put that in legal language, but that's what I'm getting at, see? So that's your challenge. You sue back, and you say, because you guys went against the sovereignty of the country, you went against me, one of the sovereigns of the state. You are committing a treasonous action, or could be, depends on how strong you want to word it, then you say, you've injured me by this action of yours. Time out for tape. Okay, you're saying, you've injured me by taking over like that. By what authority do you presume to take over the sovereignty? Okay? And if they don't show it, then I want damages for my injuries. You understand? Injury is the injury. Damages are the money owed to you because of the injury. Okay?
So, that's great. So now if the other party can't prove their damages, and you go ahead and you count...
Well, that's what lawsuits are all about. No, you don't go ahead. You already did it. That's why they can't prove it.
Right.
You said if they can't prove it, that tells me you already made the challenge.
I did.
You already did the counterclaim.
I did.
Oh, okay. Well, then what's the problem?
I didn't do it yet. I didn't do it yet. But they don't have... this guy can't prove damages.
Well, wait a minute. Did you raise the issue or not?
No.
All right, if you haven't raised the issue, then don't talk about it like you did.
Oh.
Okay? Put it in future tense. Okay? You're going to raise the issue. And if they can't answer it, then they lost the suit. That's what you're suing for, right?
And then I can go ahead and sue them for the damages for taking my freedom away for the last 2 years.
Well, you make the accusation, and if they lose, then yes, you claim your damages, right? That's exactly right.
Because I have great doctors and great producers that can actually prove.
Well, that's
I
wonderful,
wasn't
but you
able
have to put it in paper and you have to sue them for it.
Okay.
But remember, you're not
Right.
suing for what the great doctors say. You're suing because they took away your rights, maybe, or whatever it was.
Yeah.
And you're saying, what was your authority to do this?
Yeah.
Where does it say that you can take over the sovereignty of the state? Where does it say you can prosecute the sovereignty of the state? By what authority do you override the government code which says that the people do not yield their sovereignty, and you're forcing me to yield my sovereignty to you? Where did you get that authority? Okay? Does the government code mean anything or not?
That's great. Does that tie in also
right.
to malicious prosecution?
Well, malicious prosecution is a little more delicate. Again, malicious prosecution is a very common thing. And what you do is you go to Matthew Bender, which I did not prepare and study that particular item, but it's in there. I think I've seen that one. And they'll give you all the criteria for what malicious prosecution is. You look at it and decide whether or not your case fits. Okay? And you can pick up and do a lot of this stuff. By the way, all of these cases that we talk about, that you've brought up this whole evening, generally fall into two classes. One of them, common law classes. One of them is called trespass, and the other one's called trespass on the case. Now, trespass means that there was violence involved. Okay? If you're injured, you lost some blood, you got some bruises, that's trespass. All right? Trespass on the case is more administrative in nature. If there's no violence, then it's trespass on the case.
Physical violence.
Well, yeah, violence.
Put you in jail, then it's right.
Yeah.
Mental violence.
False arrest is considered trespass, even if they were very gentle with you. Okay? That's a physical taking of your body.
If they took your money, it's a trespass.
Right. It's the physical stuff. It involves violence, involves force. All right? That's different from an administrative thing where somebody says, oh, by the way, you owe me money. Well, that would be trespass on the case from your point of view.
If they physically took money, then it's trespass.
Yeah, but if they send a bill to you saying you owe me money and I'm going to sue you for it, and they publish out there that you're a deadbeat, you don't pay your bills, and ruin your reputation, that would be trespass on the case, because there's no violence involved. It's just that.
But if they physically took money, then it's trespass.
Well, how many times do I have to tell you?
Let's make sure it's not changing. I'm trying to get that very clear, because they take property.
I thought I was clear.
Without a court order.
It's physical. Force was involved. You have to use muscles to pick it up.
What about if a person, like a construction worker that was... What about a construction... Sorry. What about a construction worker that actually assaulted me physically?
Sounds like violence to me. That's trespass.
And the city attorney awarded me that. And there's a police,
I believe there's, how many times do I have to tell you?
Yeah.
Physical violence is trespass.
Great.
Okay?
Such a great case.
Well, if you have such a great...
So we could persecute it.
Well, because it sounds like you had people that are not on your team. They're against you for whatever reason. I don't know. You haven't told me enough about the case for me to... I can't read your mind. Basically, if you got trespass on the case, or trespass, that's for you to decide. Where's the violence in this? And where's the physical action as opposed to administrative type or non-physical? Ruining your reputation is non-physical. But putting you in jail is physical. Okay? Taking your property is physical. That's the trespass. And you've got to determine, classify these things, but you always sue for both anyway. If it doesn't fit one, it'll fit the other. Yes, sir.
Okay, to research more vindictive prosecution as opposed to malicious prosecution, we can't really go into the civil stuff from vendor forms of pleading and practice and P&A because that's civil. This is a criminal complaint the city is trying to do. So what we do, go into Witkin criminal procedure? Or?
Well, Witkin criminal procedure would work, but so does Matthew Bender. They have criminal stuff in there.
Get the civil first and then go to the criminal?
Well, I don't know about that, but why not?
Or does Bender have criminal?
Right, which one can you move fastest on? Do your research. Look up both. You're in the library, right? I don't want to sound petty about this, but look, you got to look and see. I don't know which you do. You know, I'm going to slide under a rock and disappear when you start asking me questions about what to do in your case, because you never give me enough detail. I'm giving you some of the general theories. Our whole evening here, by the way, and what I prepared for was to answer specific questions about form of motions. Now, we got a lot of side issues in there too, but I didn't come prepared to answer those kinds of questions. Okay, you can't know all the answers on everything. But I did prepare for motions, and here are the physical things, and here's the resources for the motions. Yes.
How long did you educate yourself before you tried your first case?
I didn't have a chance. I was pushed into it.
Right.
Okay, so, everybody gets desperate once in a while.
So you went in there completely blind and then started educating?
Well, what happened is that I had a cause. I had a dying father, and people were doing things that affected his security, his life, his home. And so I was there to try and I was really after to stabilize his situation and take the worry, the load off of his mind. Okay? And so here's these clowns out here just trying to make life hard for him. All right? Well, and all out of greed. All right? These people that were taking care of him got him to sign over the title, overdosed him with actual prescription drugs, had the paramedics taken to the hospital, and while he's in the hospital, they sell the home and disappear with the money. Okay? Now, in anybody's gut, you know that's wrong. But when you go to the court, and the court tells you that they're leaning over backwards to give you the benefit of the doubt because you don't have an attorney, and then you keep losing the motions and things, that tells you that the courts are not working as advertised. So, and you're in this constant battle of, they hit you with a motion, you're trying to live, and you're trying to handle the case at the same time, and you're trying to learn at the same time. So, life is tough. So you meet the challenge, okay? You have to rise to it. If you're going to spend nights without sleep, that happens. And so you go, you do it, and so I had a great opposition attorney with absolutely no integrity. And he did everything, and boy, he kept me running. Well, that's how I learned.
Right.
You know?
Trial by fire.
Yeah, there's a story about this guy. You get a lesson from this, okay? There's a story about this guy that he wanted to be a great swordsman. This took place in ancient China, I guess it was. So he goes to the man who had the big reputation for the best swordsman in all of China. So he goes, he says, I want to be your apprentice. Swordsman says, go away, kid. You don't know what you're getting into. Just go away. Well, he's persistent. Took him about 2 or 3 years, but he finally got the guy convinced, yes, he was serious. He wanted to be a swordsman. So finally the swordsman says, look, I'll take you on as an apprentice, but only if you do exactly everything I tell you without question. You must obey every instruction. So yeah, he wanted to be a swordsman. He says, all right, he says, here's your sword, wear it at all times. For the next 2 years, that's all he did. He washed the dishes, he cleaned the house, he did or cleaned the cave, I guess it was. But he did all this stuff, and he's wearing this dang sword, and 2 years, nothing. When are we going to learn, You said you're going to do everything, you're going to do it. So he had to live 2 years with this sword. Well, what happened? It became a part of him. After 2 years, he's doing his work, as usual. All of a sudden, bam, he gets hit by the flat of the blade from the master. What was that for? He says, you weren't on guard. Okay? And from that moment on, for the next 3 years, there was no peace. He was under attack all times, day and night. Okay? And that master just harassed him to death on this. Well, eventually the master died from old age, and he became the new master swordsman of the country because he lived and breathed it, and he just was, constant. That's what you have to be a good swordsman. Well, same thing happened to me with law. Every moment this guy's throwing motions at me, and by the way, I was throwing motions back at him, okay, because in my research and defending against his motions, I found stuff to go after him. And so I was moving for consolidation of cases, I was moving for contempt of court, I was doing all sorts of stuff, but I was always depending on the judge, so I always lost. But at least that's how I got my education. So I learned to be versatile because of the heat of the fire of the courtroom. And this is what you've got to do. You want to learn this stuff, I come in here, I'm very glib, okay? I make it look, oh yeah, we do this, we do that. You've seen speakers like that before, right? Well, I'm just one more in a long chain of speakers that's glib about things. But I'm giving you one thing that's different than all the other speakers. I'm telling you what the next step is when you walk out of this room. And that next step is you absolutely must link together. You got an issue you keep talking about, you've got an issue, you got an issue, and so forth. Gather up other people who are here. No one person is going to remember everything that I said. Okay? You have what I call a group mind. So, one person is going to remember what the other one forgot. And as you explain it, you remind each other. That explaining process crystallizes things in your mind. There is no way to learn a subject better than to teach it. Okay? A doctor, when a doctor goes through school, medical school, he gets through the routines and so forth. Now he gets into residency. The doctors have a saying. They say, see one, do one, teach one. And what they mean by that is, let's say you're learning surgery. You see how it's done. Then after you see how it's done, you actually go in and you do one. Of course, you have supervision and so forth, by the expert, your co-workers. But you do it. And then after you do it, you teach another doctor how to do it. And it's that teaching that does the crystallizing. So you've got to get together in a group. Questions will come up. And when you argue back and forth, you're actually teaching each other. Somebody remembers something someone else didn't and says, well, this is how it's done. This is what he said. This is what this is what my research covered. Then you will get the benefit. If you don't do that, you wasted your money tonight. You must get together. And I'm happy to put on more things to talk about if you have questions and if you want to have situations where you all get together and we hash out a specific problem and strategize. That's fine. I'm happy to help. But you must interact. No interaction means no mental capital has been built. And I'm telling you, this is so important. There's one guy that has done very well with this up north, and some of you know him, Al Thompson. Now he's got a little problem right now. He got rearrested. Okay. Yep. Yeah. He's been rearrested again. And no, about 2 days ago. 3 days, right. So they came after and he doesn't even know what for. He said they just grabbed him off the street. So, whatever it is, but you see, Al Thompson is an exception to the deal. It's true he studied all this stuff, but he's also a political target. They don't want him for the money. They want him for the headlines. See, he's become a big enough name in the headline business, the newspaper business, that anything happens to him, he's in the headlines. Okay, he's been on 60 Minutes. So this guy has got a special problem, which I don't know if we can help, because, the powers that be do know how to break the law if they're desperate enough. And they're plenty desperate with Al Thompson. So he's kind of an exception, but he has done very well. He's quashed subpoenas on his own order. He's beat them at their system. When he was in court this last time, and when he was in jail last time, he did 80 days. And the judge said to him, are you going to obey the order? They were holding him those 80 days for contempt of court because he refused to sign the papers. Okay? And so he said no. He says, I'm not going to lie. And he says, and he demanded to be released. Well, the federal attorney, who is on telephone presence, calling from Washington, D.C., the federal attorney is saying, Your Honor, he says, we can't let him out. Sometimes it takes a year and a half to coerce him to sign. He actually used the word coerce. Yeah, we got that on the record. Okay? So the judge cut him loose. He was out of jail. From the moment the order was given to cut him loose till the moment he got on the street was 2 hours, which is record time to get out of jail. Usually I let you out like 3 a.m. You got the order in the morning, and it took him that long to figure out how to get you out of jail. No, he was out in 2 hours. And he's using all these techniques. But he's got, and I've tried to warn him, I've told him, look, you're not just a litigant, you are a political entity. And as such, there's political capital to be won if they can beat you. And they're going to do what they can. And I've told him to be aggressive and to go and sue them. Well, he delayed and delayed and delayed. Finally, they figured out another way to attack him. We don't know what it is yet. Okay? But they have. So, you understand, it's not an easy fight. Be nice to everybody. Yes, sir.
We were discussing something earlier. If you're suing a public official, can that public official use the attorneys of the public entity they work for to defend
whether they do or not, you have no control over that. You know.
Well, no, I'm just saying, can they use that to defend them if you're suing them in their personal capacity? Because that means the taxpayer, the people, me, is paying for his attorney.
Let me tell you what happened. One time there was a case where this person personally sued one of the, whoever it was, some person working for the government. The government came in and said, you can't sue him, he worked for us. You should have sued us. So the plaintiff said, great, added them as a defendant. Okay, glad. Then they said, you can't sue us, you have to go to the Court of Claims first. That got up to the Supreme Court. The Supreme Court said, nope, don't have to go to Court of Claims. Because why? Because they volunteered to be defendants. Okay? It was a contract, right. They agreed, and so they waived the Court of Claims. So that's what happened there. And they will do that. And so if you sue a federal official in a state court, and then they remove it to the federal courts, what I would do is I would enter a motion, or not a motion, but I would enter a notice to the court. Let's call it, so you can make up names. I would say notice of concurrence. All right? Means I agree. In the body of it, I would say that, plaintiff, because you're the plaintiff, right? You're doing the suing.
Right.
So you say, and I agree, yes, it should be in federal court. No problem. Now what happens? You get in the federal court. Who's the plaintiff? Right. Who's the sovereign of the court? Right. Whose suit is it? Right. It's your court anyway. It makes no difference whether it's state or federal, because the court is wherever the sovereign and his following, his courtiers are. I forget how it says it in the dictionary, but something worse to that effect. So you can be in there and you still issue your orders. You have a good time.
Well, that wasn't the issue here. It was always in federal court.
Oh, okay. Well, then fine. But who's the plaintiff?
The commissioner in a municipal court.
The commissioner is the plaintiff?
No, I'm the plaintiff. He's the defendant.
Okay, so what's the problem?
Well, it's just that the Attorney General decided 2 weeks ago to step in as his attorney.
Well, fine. Now, let's say he steps in as his attorney. You're talking about the state attorney general? In a federal court?
No, it's a federal court. Yeah,
it's a federal court, so he steps in. All right. Well, here's an issue that you could raise. Again, this is strategy. I'm not saying you'll win. I'm just saying here's a technique to kind of hit back. All right? Well, I think a legitimate question has been raised. You say, by what authority does he presume to represent this guy in federal court? What's the reasoning? All right? Now, in the absence of a good reason for being there, it looks to me like there's a conspiracy here. Looks like a Title 18, Section 242 violation. Ooh, conspiracy, right? When two or more go upon the highway, and blah, blah, blah.
Yes.
Right. Yeah. So I would bring in an 18242 and just see where this goes. Now, I might be wrong. It might provide reason, but sure be fun. Let them think about that one.
Well, hypothetically, that's actually one of the things we were looking for.
Sure.
But if they claim, well, he's our employee, now that brings the next
are you telling me that top management certifies that this is state policy to do these things? Wonderful. I love volunteers.
Yeah, because that would
Sure.
volunteer them into the case.
Sure,
wouldn't it?
that's what I would do, yeah,
Okay.
Right, any way they go in, this sounds good to me, so far.